Good afternoon, everybody. Welcome to our very exciting webinar today with Natasha Hausdorff on international law and the law of armed conflict. Um, we also have Rhonda, most of you know, from DC, and she's going to introduce Natasha and moderate your questions and answers. So feel free to put your questions in the chat box, and I'm going to turn it over to Rhonda. Thank you.
Thank you very much, Alyssa, and thank you, Natasha. We are thrilled that you rescheduled with us today. It's a great way to begin 2026. I have a formal introduction, but I also wanted to say one of the very exciting things about working with Natasha is, as anyone who has looked at any social media knows or has done any sort of education on this issue, the amount of ignorance regarding international law out there is stunning. And people who should not will quote international law or international human rights law as if they know what they're talking about. And they often don't, especially to Israel's detriment. So that is why we are very excited to hear from Natasha today. She is a leading voice confronting anti-Semitism and a prominent defender of Israel's legitimacy and security. She is a barrister and commentator on international law, foreign affairs, and national security, widely recognized for her evidence-based challenges to take on distorted narratives and her ability to communicate the correct information. She knows how to articulate the moral and strategic necessity of the Jewish state as a democratic anchor in the Middle East and otherwise, and is a frontline defender against rising Western extremism and understanding the essential role that Israel plays. She's a sought-after keynote speaker. You will see her on television, on CNN, the BBC, Sky News, and Fox, and she has written for a number of publications. She holds law degrees from Oxford and Tel Aviv universities and was a fellow in the National Security and Law program at Columbia Law School in New York. She worked for Skadden Arps in London and Brussels and clerked for the president of the Israel Supreme Court, Chief Justice Miriam Naor in Jerusalem. She is the legal director of UK Lawyers for Israel Charitable Trust and is the founder of the Center of International Rule of Law. Natasha, we are thrilled that you are here. Thank you for taking the time. We can't wait to hear this. And as Alyssa said, please direct your questions in the chat to me, Rhonda, Lees, and Natasha. Thank you. Oh, very quickly, I do want to introduce a couple of people. Joel Margolis is our legal commentator. Richard Fulton is our previous executive director. Alyssa, Richard Huberman, Kathy Horowitz, and I are board members. And if I missed anybody, I'll fix it later. Okay, thank you very much, Alyssa, Natasha. Thank you.
Rhonda, thank you so much. Always great to see you and to see quite a few familiar names who've joined us, which is wonderful. Good afternoon to you all. It's wonderful to be back giving a lunchtime seminar to the Association of Jewish Lawyers and Jurists in the US, been a member in the UK of that counterpart for some time. And I think it's an incredibly useful forum to discuss aspects of international law in particular that are so routinely misrepresented against Israel. Rhonda is absolutely right in her introduction that there are many supposed experts, especially in terms of the media commentary that we have had over the last 2 and a bit years, with everything that's been going on in the Gaza Strip. But so often these falsehoods about international law, and in particular the law of armed conflict, are able to percolate because general levels of literacy on international law in general and on the law of armed conflict in particular are not especially high. And as we have seen the last 2 years evolve, I think it's become very apparent to all of us that we have the 7 kinetic fronts that Israel has been fighting and winning in pretty miraculous ways in many respects. And we have this eighth front, which comprises this discussion of international law, the international media's coverage of these developments, everything that we have seen on university campuses, in the International Legal Academy in particular. All of this ultimately has centered on delegitimization of Israel and a misrepresentation and even weaponization of the international law of armed conflict to seek to demonize the Jewish state. So, what I propose to do is give an overview, a brief overview of the main principles of the laws of armed conflict, sometimes also called international humanitarian law, and then relate those to some of the key misrepresentations with respect to Israel's battles against Hamas over the last couple of years. But the most important part of this, as far as I'm concerned, are your questions. So I look forward to receiving those on anything, law Israel related. The law of armed conflict is quite difficult, I think, for non-military lawyers to properly comprehend, for the simple reason that it operates with very different expectations to the way that we conduct our day-to-day lives. There is an expectation, a very gruesome one, that people will die on a routine basis in war, and there is an expectation that civilians, very tragically, will die in war. And what the laws of armed conflict or international humanitarian law do is try at a basic level to regulate what is ultimately the most chaotic environment any of us can possibly imagine, and to do that in a way that makes that suffering as limited as possible and engenders a humanitarian element into armed conflict. This is a regularization of this concept of war that began really on a state to state level. The famous aspects of the laws of armed conflict center around the Hague Regulations and the Geneva Conventions. And while they began regularizing the manner in which two armies would be able to properly face each other. And there were basic rules of engagement for that. After the Second World War, those Geneva Conventions developed the law substantially to seek to protect civilians in armed conflict wherever possible. And so from that, we have really four general principles of the laws of armed conflict, which are worth summarizing for our discussion today. The first of those is military necessity. A law-abiding army may only take action on the battlefield that is militarily necessary to advance its goals of the armed conflict, its legitimate military aims. So if there is action that is contemplated that is not considered to advance those goals, or there might be an alternative approach, then there is an argument to say that, plan A may not in fact be militarily necessary and may not therefore be the lawful approach. All of these concepts, as you will no doubt see in due course, are pretty general and in some respects also nebulous. So most of the time, there is a great deal of discretion afforded to the reasonable military commander. This is the officer in the field that is having to make these assessments in real time in many circumstances. And they will, all of them, have training in aspects of the laws of armed conflict to be able to inform the decisions that they make on the battlefield. But that is really the first principle, that a law-abiding army may only take action that is militarily necessary to advance the aims, the legitimate aims that they have in pursuing an armed conflict. The second key principle here is that of distinction, and this requires that armies distinguish between civilians and combatants, that they distinguish between their own civilians and combatants, and also between civilians and combatants that they may encounter on the battlefield. So with respect to their own armed forces, it is to wear the appropriate uniform and insignia. It is not to dress as civilians if they are in fact combatants, members of the armed forces. And on the battlefield, it is only to target military individuals, combatants, and also military targets, infrastructure. and to make sure that that distinction is kept between civilian individuals and civilian infrastructure, and then what are legitimate military targets. The third principle, before we get to the fourth, is perhaps the most misrepresented part of international law, full stop. And this is the principle of proportionality. Proportionality is not about weighing up casualty figures. And when Rhonda introduced this session and talked about all of the misinformation on media, I'd say that what I hear most routinely misrepresented is this notion of proportionality. And you will hear sometimes the world and his wife claiming that Israel's conduct has been disproportionate. This is a legal term. It is a concept in public international law, in the law of armed conflict, but it has a very specific meaning. Proportionality requires that the reasonable military commander, when deciding on whether to take a strike, weighs up the expected, anticipated military advantage of a strike against the expected civilian or collateral damage. Now, there is no straightforward, direct formula for making this assessment. And when you have certain articles that have appeared in the press that suggest, what Israel's acceptable civilian casualty ratios are, all of those are without question false. Because Israel does not have, and in fact, modern militaries, moral armies oughtn't to have straightforward formula by which they say, 4 civilians per one military target is acceptable, but 40 isn't. This is always going to be a balancing exercise, and it is always going to be informed by the intelligence and the material available to the military commander making a decision on a strike. And sometimes that is in real time. So going into an armed conflict like this, a military like the IDF has banks of targets and information and intelligence about them. And those targets will be military targets, but they may be, and they unfortunately often are in the context of the Gaza Strip because of the tactics that Hamas deploys here. They may be and often are in close proximity with civilian infrastructure and even with civilians themselves, human shields that Hamas has used throughout this conflict. That information, in Israel's case, is compiled and it is put into target sheets that form part of target banks. And those go through a very close, careful assessment, both by the intelligence officers, the combatant officers, the combat officers, and also Israel's military lawyers. And it's worth just saying a word here that the Military Advocate General Corps actually sits outside of the usual chain of command. They are answerable to the Attorney General. And the reason for that structured approach is so that the army lawyers in the IDF are able to call the shots on strikes, for instance, are able to pull rank, if you will, on officers, even if they are more senior to them. Lawyers in the IDF are given a very elevated and I think remarkably unprecedented role so far as militaries around the world are concerned. And they are specifically taken outside of the chain of military command so that they can make those determinations, as I say, often on a case-by-case basis. And that legal analysis, that proportionality equation, balancing exercise is carried out, sometimes at various stages throughout the selection of a strike target, through the development of thinking as to the timing of day that a target is struck, the choice of munitions, and any other arrangements that the IDF may be able to make around a strike to adjust that proportionality analysis and minimize the harm to civilians as a result. And that brings me on to the fourth principle, which is that of precaution. And that requires a moral army to take precautions that are feasible to minimize civilian collateral damage. Israel has led the way in so many respects on the techniques that it has developed in order to promote this principle of precaution. It has sought to evacuate civilians from throughout the Gaza Strip. It has created humanitarian corridors. It has, in fact, protected those corridors and evacuating civilians, while Hamas has sought to kill civilians that have been seeking to leave zones in the Gaza Strip that were designated as intensive combat zones. It created the Al Mawasi humanitarian zone, which unfortunately Hamas used and abused throughout this conflict to fire, for example, missiles onto Israeli civilians from within that designated humanitarian zone. The choice of munitions has always been a central factor in the IDF's approach to minimizing civilian casualties and to adhering to this principle of precaution. Many people in the audience may have, in fact, seen footage of certain strikes indeed before the Gaza war, that take out, say, one floor of a residential building. That is in relation to terrorists using a particular floor of what is otherwise civilian infrastructure. And in order to minimize the harm to civilians and take precautions to avoid civilian casualties within the rest of that structure, Israel has developed techniques, munitions, but also means of deploying those munitions to really target specifically terrorists operating within that otherwise civilian infrastructure. The knock-on roof technique may also be familiar to many people on this Zoom. The scope for using that in the current Gaza war has certainly been more limited, but this is a technique that Israel pioneered, that it developed, and it involves firing onto the roof of a building that is about to be targeted a particular munition which makes a loud bang, but doesn't in fact cause destruction to the building as a final warning to civilians within that
He
structure
said, what's
to
too much for
evacuate.
him?
I'll just ask whoever, there's quite a bit of background noise, if we
That
could
was shivering.
we're on mute.
I know,
Apologize.
he
We'll
was
get
shivering.
everybody muted.
I'll just hang on. So those are the four major principles of the law of armed conflict. You don't have to take it from me as to how the IDF compares with respect to other militaries around the world. There are many that have written on this subject. Prominent amongst them, of course, are Colonel Richard Kemp from the British Army, John Spencer from West Point in the United States. I went into Gaza with a group of very senior military officials from 6 NATO states. And on their return, many of them also wrote articles about their experience and compared it with their experience professionally in their own militaries. And frankly, there was no comparison between Israel's measures to not just adhere to those laws of armed conflict, but in fact to go far above the requirements of the law of armed conflict and set standards which, frankly, many other armies, the British, the American, the Swiss, the French, the Canadian, would struggle to come close to. Now, a significant part of the reason that Israel has set these impossibly high standards is, of course, the unique theatre in which the IDF have been engaged. John Spencer has written extensively about this, comparing the type of urban armed conflict that the IDF has faced over the last 2 years to other conflicts in Iraq, including and also in Afghanistan. And the level of intensity of Hamas's pre-embed within civilian infrastructure in the Gaza Strip, and in particular the tunnel system that Hamas had spent so much time, energy, resources in preparing, has really led to an unprecedented environment in the Gaza Strip. And Israel's ability to conduct this war has evolved as it has had to come up against these immense challenges and develop new procedures and new abilities to do so. So when I went in to Gaza, it was September 2024, and the general who was in charge of tunnel warfare at the time was briefing our group as to the progress that Israel had been making in mapping out the Hamas tunnel system, in fighting Hamas through these tunnels, and in ultimately destroying as much of that tunnel system as they were able to once they had defeated Hamas in the various different sectors. And at that point, General Goldfluss indicated to us that in many parts of the Gaza Strip, the IDF was in fact fighting more quickly through those tunnels underground than they were above ground, and they were able to pop up and surprise Hamas units above ground through utilizing that very same tunnel system. Now, these techniques and these abilities to pinpoint the enemy and to target them in amongst the civilian infrastructure are all part and parcel of the way that Israel has striven to fight this war in the most humanitarian way, but to target Hamas successfully while minimizing civilian casualties. Many have argued that this is why what would otherwise have been, a swifter process, perhaps if a less careful army were to seek to bombard more from the air, that Israel has in fact often had to go house by house, bulldozing many of the civilian houses which had been booby-trapped by Hamas. So when they sat in their tunnels, they had video cameras above ground within these civilian infrastructures, so that when they saw IDF soldiers coming into these buildings in order to sweep them, to clear them of civilians, or to target terrorists within them, Hamas would take that opportunity and remotely detonate those explosives that had been set as booby traps. That led to the use of the increased use of these armored bulldozers, which many of you may recognize from media coverage. But of course, the central reason for that, and equally the central reason for the amount of destruction that you will be seeing on your television screens throughout the Gaza Strip, is because of the manner in which Hamas had turned these civilian areas into terror bases and had in fact booby-trapped so many of these ordinary houses. Now, all of this, I think, needs to be seen in the context of the manner in which Israel has been forced to fight this war. I called in October 2023 for Egypt to open its border to civilians that wish to flee the Gaza Strip. I know that Colonel Richard Kemp echoed that call, but frankly, I failed to hear it, not just from other military officials or indeed other politicians, but also, and this I found particularly shocking, from every single humanitarian organization that I engaged with. Egypt had and still has an international law obligation to facilitate the safe passage of civilians fleeing civil disorder in the Gaza Strip. It signed itself up to the African Union Convention on Refugees, which has a much broader definition of refugee than the International Convention, and it is under that international treaty that Egypt had this obligation. It ratified it in 1980, and it has yet to leave this treaty. And instead of facilitating the exit of civilians into Egyptian Rafah, and I'm not here by saying that Egypt necessarily had a responsibility to take these civilians in, to provide them with citizenship, certainly not. The requirements under the convention are that they essentially facilitate the exit of these civilians from the Gaza Strip. And when one thinks about the ease with which these civilians could have been provided for, in Egyptian Rafah, the other side of the border, which is the Sinai, where there is more space than anyone knows what to do with, the idea of setting up a tent city where these civilians could have been provided with humanitarian assistance, with food supplies, with medical supplies, with medical treatment in field hospitals, and critically could have been separated from Hamas. When one considers how different the last couple of years might have looked if that had in fact been implemented, we could have certainly avoided a great deal of the tragedy and indeed of the international opprobrium against Israel. When one considers the ability of the IDF to fight this war in the Gaza Strip against Hamas without their ability to use the level of civilians that they have done as human shields, without the ability to fire missiles out of the Al Mawasi humanitarian zone, where we see, if we think of an alternative reality where Hamas could have been separated from the civilians, then I think the situation would have looked very, very different. And I would suggest that there are some very important questions to be asked about why the international community did not echo that requirement. When one considers the certainly the influence that the United States has over Egypt and the immense aid that it provides, which Egypt is, of course, utterly dependent on, then there is a very, very substantial question here to be answered as to why this simply wasn't demanded of Egypt. And I frankly find it very difficult to take anyone who professes to care about the plight of Palestinian civilians over the last 2 years seriously if they have not made this very straightforward call for something which would have ultimately changed the situation beyond recognition. That is not in and of itself, of course, part of the law of armed conflict, but it is a very important aspect of what is a key source in international law, treaty law, which sits alongside international customary law, a key source of international law with key responsibilities, legal obligations for the neighbouring state of Egypt that were simply not addressed and that it was not called upon to uphold. The last thing I'll perhaps say before we open up to your questions is not strictly legal, but it is based on my experience of engaging with the IDF at many, many different levels for the better part of a decade. And that is a reflection on what this conscription army stands for and what it is ultimately driven by. And that is very intimately connected with its makeup. These are ordinary individuals for the vast majority who have day jobs, who are doctors, carpenters, school teachers, some lawyers, and who ultimately know what is required of them when Israel is under threat and when Israel is in an armed conflict or state of war, that they put on their uniforms and they go to defend their families. But ultimately, these are all products of the only democracy in the Middle East. And they are products of the moral environment in which they have been raised. And this is reflected in the ethical code of the IDF, which is imparted to every single recruit in their first week of basic training. And it sets out the purity of arms and the importance of the preservation of life above all on the battlefield. And one sees this reflected, I believe, in those individual decisions that are taken within that framework of the law of armed conflict, when it does ultimately, the buck stops with the reasonable military commander in the field that is having to make these calls. Unlike perhaps, volunteer armies, which may take a particular segment of the population, and there are all sorts of, commentaries on the nature of individuals that volunteer to go to war. The fact that this is a conscription army and it is reflective of the society that the broader state is, and it is reflective of those Judeo-Christian values that the state of Israel embodies and promotes. One can definitely see that filtering through to the approach the ethical code, certainly, and the conduct more broadly of the IDF. Now, that is not to say that every army does not have bad apples. There are processes in place. The military lawyers and the military advocate general investigate and punish where there is evidence. There is, obviously a legal process, a trial. But the flip side of what we have been seeing portrayed in the international media and the grotesque, false allegations, including of genocide, which are gaining currency in the international media, um, turn turn what are ultimately legal terms on their head. We see this amongst a variety of blood libels, unfortunately, that have been gaining traction against the Jewish state, occupation, ethnic cleansing, colonialism, apartheid, and now genocide. They, frankly, those blood libels that relate to Israel's conduct on the battlefield ignore all of the measures that the IDF takes to minimize civilian casualties, which, as I say, are unprecedented. They completely ignore the moral, ethical code of the IDF, which every single military official I have engaged with outside of Israel who has had cause to interact with the Israelis has remarked on, frankly. But they also ignore the facts on the ground. And one of the key drivers behind a lot of the falsehoods about Israel's approach to the armed conflict in Gaza have been the false casualty figures that Hamas has routinely put out. Now, we know that we cannot trust figures coming from an internationally prescribed terrorist organization, but these figures have also been routinely proven to be false. And I can certainly circulate some of the work that UK Lawyers for Israel has done on analysing the casualty figures that have been put out by Hamas, also analysing the false media reports that some of which consistently suggested that 70% of the casualties were women and children. The reality is that in Gaza, we have seen an all-time low in terms of the casualty ratio between civilians and combatants. Now, I stress that this is not relevant for an assessment of Israel's compliance with international humanitarian law, because that is not effects-based. The law of armed conflict is always analysed from an intention-based perspective. What did the military commander know before the strike was taken? What was the assessment made on the basis of the available knowledge, the available intelligence at the time? Nevertheless, when we look at the casualty ratio, which throughout the first part of this war was something between 1 to 1 and 1.5 to 1, we can safely say that is unprecedented in urban armed conflict generally. And when one considers the additional challenges that Israel was presented with in this particular context, where Hamas's use of human shields was absolutely central to their military strategy, it is utterly remarkable. Now, the casualty ratios are unfortunately based only on partial information, but these ratios, I stress, are on the basis even on Hamas casualty statistics, which we know to be false. They did go up throughout the course of that war, but in every respect, they do appear to have remained below the ratios that were put out by the American health authorities with respect to Afghanistan and Iraq, which were more disturbing 3 to 1 and 5 to 1 civilians to every one combatant. So with that nod to the numbers and with perhaps 20 minutes left for questions, I really look forward to taking them. Rhonda?
Thank you very much. This was just fantastic. Before we go to the questions, and I want to recognize a couple of additional people. Stanley Fink, board member, Alan Nesbitt, board member and treasurer, and Richard Heidemann, one of our recent honorees at Pursuit of Justice Award held here in DC last month.
Hello, Richard.
So very excited to hear this. And one of the questions that came in independently was, is it, in fact, in the Geneva Conventions that Israel has not only a right, but an obligation to protect its citizens? And how has that issue been sort of people ignore it. In other words, they're willing to jump right into everything else, and they're aggressive military, and this concept of, oh, we'll only give you defensive weapons, not offensive weapons. Can you talk a little bit about the genesis of that and how? Sorry, I've got to admit someone else. How that affects any part of the conversation?
Right, absolutely. So, first of all, this concept of self-defense is critical. This is not bestowed on states by any international law or convention. It is, in fact, an inherent right which is recognized under the Charter of the United Nations, Article 51. But it is recognized as inherent. It is, if you will, God-given. There is a general acceptance that international law does not bestow a particular right to self-defense or necessarily an obligation to defend your civilians as a state, but that is ultimately the primary purpose of any nation state is the defense of its civilians. So that is ultimately taken as a given, and nothing can encroach upon that God-given right. The regularization of the law of armed conflict is to ensure that if you are exercising a right of self-defense, you are doing so in a lawful fashion that takes into consideration the four principles that I outlined: necessity, distinction, proportionality, and precaution. When we come on to this suggestion of, arms restrictions or even arms embargoes, I think it's really critical that we're clear on the ability to assess Israel's compliance with international humanitarian law in the context of an armed conflict. So I mentioned already that the law of armed conflict works on a prospective basis. It is not effects-based. It is not retrospective. Therefore, to make a proper assessment of the conduct that Israel has engaged in, one has to have an appreciation of the information that decisions to strike certain targets were based on. Now, this is obviously sensitive, sometimes confidential information and intelligence that is not in the public domain. So whenever you hear people on the media saying Israel has acted disproportionately, know that they are without question simply not in a position to make that assessment, even if they happen to be an expert in the field. The fact remains that the states that I'm aware of that Israel has shared some of this sensitive data with, the United Kingdom and the United States included, have consistently said that they did not have concerns with respect to Israel's compliance with respect to international humanitarian law on issues of targeting and proportionality. Now, I gave that evidence before a parliamentary committee in the UK, in Westminster, and I immediately had the chair of this committee seeking to shut me down, principally because she had purported to, in the year previous, leak information about the UK government's legal assessment of Israel's compliance with international humanitarian law, and she had suggested that assessment was in the negative, that it found Israel not to be compliant. We now know that that was false, because when the United Kingdom instituted its arms embargo on the state of Israel, and it suspended 30 arms licenses, export licenses, it did not raise concerns about proportionality and targeting. And so we can see from its justification of that arms embargo that it has simply not made any legal assessment that there are concerns with respect to targeting and proportionality. Now, my position is very firmly that the UK's arms embargo on Israel is therefore unlawful, because the concerns that were raised by this government included aid distribution and military detention. Now, both of those, I would suggest, on the basis of what I've read in terms of the summary that the government put out of their concerns, are unfounded, principally because the issues on aid did not take into account the volume of aid that had been facilitated into the Gaza Strip, which is available, publicly available, on the COGAT website. This is the unit of the Israeli Defense Forces that's sole responsibility is for the humanitarian provision of civilians in armed conflict, and they have put out on a weekly basis the volume of aid that they have facilitated into the Gaza Strip. And on our assessments and on those assessments of nutritionists and statisticians, the aid that has been facilitated into Gaza routinely far exceeds the requirements of the civilian population. So this is just an aside that the UK's purported concerns on aid were unfounded, and likewise on detention, they did not take up an invitation to come and visit the detention facilities for Nukhba terrorists. There was an insistence instead that the International Committee of the Red Cross be permitted to investigate, and that is not appropriate where these terrorists are not prisoners of war. There is no provision for ICRC access in those circumstances, and where we have clear evidence from the Palestinian Authority that the International Committee of the Red Cross was essentially complicit in providing information that was necessary for the pay for slay policy. Israel also has a very significant national security exemption to rely on to say the International Committee of the Red Cross will not be permitted access to detention facilities. But as I say, other countries that were offered the ability to visit simply did not take that up. So that was a little bit of I think, an important, though, aside to explain that where states have taken measures against Israel, which on the face of it may indicate a degree of dissatisfaction with compliance with international humanitarian law, they have in fact been politically motivated. And when one drills down and looks at the legal justifications, it becomes very evident very quickly that these states couldn't hope to compete with the standard that Israel is setting in terms of the laws of armed conflict in particular.
Thank you very much. I see a number of additional questions that have come through, so thank you very much. Given that this is the U.S. group, although obviously international law is vital, everything that we're doing, can you talk about what actually ties the U.S. to these international laws? I mean, obviously it's the Geneva Convention and things for the UN, but if you could talk a little bit about that, that would be great. In other words, how this affects the U.S.
Yes, of course. I must remember I'm speaking to an American audience, and I fully appreciate that
That's okay. We learn.
no,
We learn.
many in America don't believe international law exists, especially if the activities of the last week are to be taken into account. But in my respectful submission, international law is a thing. It is ultimately incredibly important because it facilitates the ability of states to interact with each other. And we do rely on it for our day-to-day lives, international commerce, communications, trade, shipping, all of that. I think our lives would look very, very different if we did not have international law. I mentioned two sources of international law previously, and they are the main sources: treaty law and custom. Now, treaties are like contracts. They are laws that states sign themselves up to and bind themselves by. And I'd say that the majority of international law that the United States is subject to is what it has signed itself onto, the Geneva Conventions included. In fact, very interestingly, in 1977, the United States did sign Additional Protocol 1 to the Geneva Conventions. This is, in my submission, an example of a convention which was negotiated to the advantage of states that do not, in fact, believe in rule of law. One can see certain examples in Additional Protocol 1 of the despots and dictatorships of this world seeking to insert provisions into the Geneva Conventions in order to benefit their terror proxies and their ability to combat Western civilization. And very unfortunately, to my mind, the United States signed that convention, but never in fact went on to ratify it. And I believe it is the only example in the history of the United States where that treaty was later unsigned, when it became apparent that the United States perhaps should never have signed it in the first place if they were not prepared to ratify it. But as I say, treaty law is probably the primary source of US international law obligations. Then we come on to this second source, which is somewhat unusual, especially for domestic lawyers to try to get their heads around, and that is international customary law. Now, custom emerges from state practice and it develops over time. So ultimately, if a state is behaving in a particular way, believing themselves to be bound to behave in that way, over time, their behavior will give rise, will crystallize a rule of customary international law, which will bind them going forward. And the only way that a state can successfully extract itself from the formation of custom of that nature is to become what is called a persistent objector. So if it is consistently demonstrating that it does not agree and it will not comply with this rule of customary international law as it comes into formation, then it will be excluded from that. Those are really the two primary sources of law that the United States will be subject to. And then one has, this big question about enforcement. And there are really problematic aspects of the international legal order when it comes to this question of enforcement. Ultimately, we have the UN Security Council and the mechanism under Chapter 7 by which the Security Council members can pass legally binding resolutions, but they are very few and far between. Chapter 7 resolutions are hardly ever passed. One example was ordering Iraq to get out of Kuwait. Another example was just after the 9/11 attacks, mandating and in fact requiring all states, member states of the United Nations, to combat terror, and in particular terror financing around the world. But those examples, as I say, are few and far between. We also have the concept of the International Court of Justice. You may be familiar with a number of advisory opinions that this court has been producing, in particular with respect to attacks on Israel. We had an advisory opinion on the supposed occupation of Palestinian territory, which frankly misapplied international law. We had an advisory opinion also on the ability of UNRWA to operate in Israeli sovereign territory, which unfortunately misapplied international law. But the important thing to recognize about those advisory opinions is that they are not legally binding. The only aspect of legally binding decisions that come out of the International Court of Justice are those that concern disputes between individual states. So if two states have a dispute and they are both agreeing to the jurisdiction of the International Court of Justice to arbitrate that dispute, then the decision of the International Court of Justice is considered to be binding. But as I say, those are few and far between. That is the only really, those are the instances in which there would be international law that bites onto the United States.
Thank you very much. Another question that came up, you talked about precautions. I think it was item number 4, and believe that one of the standards is feasibility.
Yes.
And not surprisingly, UN committees and chairs and NGOs are saying that Israeli precautions are not actually effective. Can you talk about whether that standard, whether I articulated the standard correctly about feasibility, and is anything else required, as well as you've given examples of how what Israel has done, should have been feasible and effective. So,
of course. Well, look, the fact of the matter remains that the standards that Israel has applied and the measures that Israel have taken are unprecedented in armed conflict. And so there is a very strong argument to say that Israel has gone way beyond what is feasible. When you give a warning of a strike, you are warning the civilian population. You are also warning the terrorists of an incoming strike. And necessarily, Israel has, as a result of the precautions that it has taken, sacrificed significant military advantages throughout this war. Some argue that is why the war has taken so long. Others argue this has led to more significant Israeli casualties on, soldiers losing their lives as a result of the measures that Israel has applied. That is another reason I talk about, the moral standards that the IDF has applied, because they really do outstrip the way that other law-abiding moral armies have conducted armed conflict in similar circumstances. So that is what I would say about, the feasibility. Of course, we're all lawyers here. We're all going to understand that these are not hard and cut and dry situations. There is a great deal of grey area here, which the military lawyers in the IDF seek to navigate. But one thing I would highlight with respect to the opining of international organizations and so-called human rights organizations on what has transpired over the last 2 years is that I have yet to see a single UN body or international organization operating on the ground in Gaza actually approached these issues with any modicum of objectivity or fairness. And the very clear reason for that is that they are not able to operate independently in the Gaza Strip because Hamas has controlled their operations absolutely. So we have seen Amnesty International and Human Rights Watch putting out reports in the last few months alleging genocide in Gaza. And in fact, that is what the Commission of Inquiry of the United Nations based its own findings of genocide in Gaza on. But when you actually look into these reports, they start to unravel pretty quickly. I was asked to come and debate Amnesty International in Oslo and in Copenhagen about their report. And it was pretty clear to me that the two individuals who'd been put up to debate with me from the organisation in these respective cities hadn't, in fact, read the report that we were discussing. But I cited to them the methodology section, which made it clear that this organisation did not have people on the ground in Gaza. No, they said in black and white that they relied on local government authorities for the information that they put into their report. And this was a clear admission that Amnesty International took Hamas propaganda. We all know who the local government authorities in Gaza are. Took Hamas propaganda, put it into a document that was headed up Amnesty International, and put it out into the ether, which of course then gets circulated into the UN Human Rights Council, the Commission of Inquiry. Francesca Albanese, the special UN rapporteur, picks it up. It gets cited perhaps subsequently by the International Court of Justice and the ICJ. And then organizations like Amnesty will point to what these international courts and tribunals say and say, see, the ICC says so. And that function of laundering this disinformation that ultimately, when you follow the trail, comes from the mouths of the Hamas local government authorities directly, is at the center of this misinformation storm that we have been seeing of the reality of what is going on in the Gaza Strip and Israel's compliance with the international humanitarian law throughout, but also the additional standards that it's setting, in particular, taking precautions even where other militaries may judge them not to be feasible in the context in which Israel is fighting.
Great, thank you. A question was listed about why does international law, if this is in fact, does not prohibit sexual brutality and or slavery as an aspect of warfare. My understanding is that hostage taking and hostage keeping is in fact
totally
sorry
unlawful.
about that.
At a very basic level, it's because you are targeting civilians.
Right. Okay.
Which, of course, even on those basic principles of the laws of armed conflict that I set out, that principle of distinction, of taking military action that is necessary to advance your goals. When Hamas stormed the border on the 7th of October, they were very clear in their aims and objectives, and those were genocidal. They had the intention to target Jews because they were Jews, and they followed through with acts that were absolutely abhorrent in order to do so. So there can be, I know so frequently now we hear this notion that, in fact, the 7th of October was an act of resistance, or even this obscene notion that a population under occupation can resist. I mean, for starters, Hamas in Gaza have had absolute control since their violent takeover in 2007, which of course postdated Israel's withdrawal of 2005. The very notion that there is any occupation in the Gaza Strip, or has been, frankly, is founded on a complete misrepresentation of the status of the territory before Israel's withdrawal, which is outside the scope of this session on the law of armed conflict, but is also deeply, deeply misrepresentative of what has happened since Israel's withdrawal. So in all of these respects, unfortunately, what we are seeing is a weaponization of international law, turning it on its head. Projection is a very significant aspect of this. So frequently we will see what is done to Israelis, Jewish Israelis in particular, is what the international community then accuses Israel of doing in turn. We have seen that with respect to the sexual violence allegations. We have seen that with respect to starvation, because we know the hostages were starved. And the allegations of famine and starvation have been consistently debunked, again, on the basis of publicly available information of what Israel has facilitated into the Gaza Strip in terms of humanitarian assistance. But we see this as a consistent pattern. But you're absolutely right. There is absolutely no justification for the targeting of civilians with any form of violence, least of all sexual violence.
Um, we have a couple more minutes, and I also want to make sure that I leave time for a final wrap up from you. There's one other question that came through a couple of different places that I just wanted to ask you about, and that is someone asked, why did Israel or other people not publicize the fact that Egypt was in violation of and I forgot the name of the law, the African.
African Union Convention on Refugees, yeah.
Right. My understanding is that the argument given was they were afraid of the Muslim Brotherhood gathering in Egypt, and therefore they did not want to let any Gazans in. And I'm wondering if you could comment upon that, because you said about the Sinai, I mean, more land than it. I mean, that could have really addressed a lot of this. But if you could just comment, that would be great.
It absolutely would have been a game changer, and there is no real understanding or reason that I can give you other than it seems to me that the international community did not want Israel to be able to fight this war properly. And we see that consistently with respect to the rhetoric that has been used about this war, with respect to the political isolation that Israel has been subject to. This has all been for the benefit of Hamas. Hamas did not want to lose its civilian human shields, and the international community ultimately made sure that it did not by unprecedentedly keeping them in a war zone. Never before have civilians been prevented from leaving a war zone, but here they were. And again, we see unprecedented action and double standards being meted out to the only Jewish state. But it is truly shameful. The justification that I have sometimes heard is predicated on a suggestion that this would have involved ethnic cleansing. This was Israel seeking to ethnically cleanse the Gaza Strip. And in fact, similar allegations have been made where Israel sought to evacuate civilians internally in the Gaza Strip into safer zones or humanitarian zones or out of cities that it was launching large-scale military offensives against. And that is, again, turning the facts, the reality, and the law entirely on their head. When I spoke about the potential evacuation of civilians into the Sinai, that is necessarily a temporary measure. If you are setting up a humanitarian zone in Egyptian Rafah, that is a temporary measure to facilitate the protection of civilians, and suggesting that that would in some way be unlawful because it amounts to ethnic cleansing is the biggest inversion and manipulation, I think, of the general public. Well, perhaps not the biggest manipulation of the general public in this war, because there are so many others that compete, but it's certainly up there.
Fantastic. Okay, that was a fabulous summary, but if you want to give us a 30-second wrap up, that would be terrific, because this was just amazing. Thank you so much. And I know that you said you could follow up with some documents or videos from UKFLI, but in the meantime, if you would like to do that, then I'll turn it back to Alyssa.
Thank you so much, Rhonda. I supremely appreciate the opportunity, especially to speak to lawyers about this important content, because I spoke about the seven fronts and the eighth front, and ultimately, you are the army on the eighth front to fight back against this misinformation war and the weaponization of international law in particular. And it needs to be taken seriously, not just by those who care about the state of Israel, but I fundamentally believe by anyone that cares about the rule of law. Because what we have seen in terms of the weaponization, inversion, and abuse of law against Israel will not end with Israel. This is being pursued by, frankly, entities that are coming for our way of life in the West. And it is Western civilization that stands to suffer tremendously if international law is discredited in this fashion, is so devalued because of its manipulation in order to target, as I say, not just Israel, but Western liberal democracy. So thank you for your attention. More power to you all, and I will certainly circulate some materials from UK Lawyers for Israel to assist with anyone who wishes to engage more readily with this material and push back against these increasing falsehoods.
Thank you so much, Alyssa.
Thank you. Thank you, Natasha. Thank you, Rhonda, for doing such a wonderful job moderating. I'm sure there are many more questions, and we're very fortunate that Natasha is such an accessible person who always wants to teach all of us. So Happy New Year also to everyone. And we hope, especially in the new year, that you will join the AAJLJ. We're very rapidly growing and we need more of you, all of you. So thank you again and have a wonderful day.
Be
Bye-bye.
safe. Thank you. Enjoy your time in Israel. See you next month.
Thank you. Happy New Year.
Happy New Year. Thank you.